Welcome to the DRBF-CICA and EIC webinar on Enhanced Efficiency, Increasing the Value of Dispute Boards. I'm Anne Rousseau, Executive Director of the Dispute Resolution Board Foundation, and I'm joined today with Fanny Destu, who is the Director General of the Confederation of International Contractors. And it's our pleasure to be hosting today this webinar that's really to roll out an initiative that we started back in May of 2024. We hosted a meeting in Washington, D.C., where we brought together a number of important institutions and stakeholders who are all interested in the effective implementation of the dispute board process to improve the quality of the process for construction projects. And the idea that came out was to wrestle with some of the challenges that users are experiencing in the implementation and put together our collective thoughts around how we might strengthen the use of dispute boards to improve projects globally. So just to cover a few logistical details today, we are recording and we will send around after the webinar is complete a link to the recording as well as the presentation that's being made today and a copy of the paper. Now, many of you have received the paper already, but we hope to take on your feedback and ideas that we can integrate into this initiative to strengthen it and make it better. So the materials that you'll receive will have contact details for all of our organizations so that you can share your ideas and input. We also invite you to comment today, so you can take advantage of the Q&A box that the webinar offers to put your questions. We will have time to field those at the end of the presentation. And you're welcome to say hello in the chat to your colleagues. I'm going to hand things over now to Fanny to introduce our presenters.
Thank you very much, Anne, for this kind introduction. So I am Fanny Destu. I am the Director General of CICA, the Confederation of Contractors. So we are very pleased to join our efforts together with DRBF to promote the best practices for the use of dispute boards. So today we have with us Jeremy Glover, who is the President of DRBF Executive Board of Directors. Jeremy will make the general presentation of the paper, and then we will also have the perspective of the contractors with Nabil Koka, who is a member of the EIC, European International Contractors Working Group on Contract Conditions. We will also hear Richard Touroud, who is our chairman of our CICA Working Group on Construction Contracts and Multilateral Development Banks Working Group. So I will now turn to Jeremy, who will be presenting the paper today.
That's great. Thank you, Anne. Thank you, Fanny. And thank you all for joining us today. It's been my pleasure to work with CICA and the EIC to help prepare this paper. And I'm going to talk, to begin with, a little bit about dispute boards and why they can be so valuable in helping construction projects move forward effectively and efficiently. By way of a reminder, the dispute boards in 2025, they basically have two roles. Dispute avoidance, the process by which a dispute board works with the parties to help them avoid potential disputes. Now, this can take many forms. For example, during the site meetings, the dispute board can review the status of outstanding issues. They can help the parties work together to avoid any potential claims actually becoming disputes. Or parties can seek joint opinions at the outset of a dispute to see if they can put the rest together promptly. And second, there's dispute resolution, and that's about the resolution of claims in real time. And this is always critical to the success of the dispute resolution process. And here, a dispute board can deliver a decision or a recommendation on a formal dispute at the request of one party. And one of the more interesting trends we're seeing in 2025 is the increasing emphasis on dispute avoidance. And just a brief word about the purpose of the paper. Well, as I'm going to explain, I think whilst the track record of dispute boards is solid, it's good, the implementation of the dispute boards themselves is not without difficulty. So the paper aims to consider and address some of the practical challenges that are faced during the implementation of dispute boards, and also to try and make some recommendations for how this process can be improved. And as part of the preparations of the paper, we, CICA, EIC, DRBF, we've discussed those challenges and potential solutions with others, including many of you, representatives of the development banks. And of course, from a dispute board point of view, 2025 marks the 50th anniversary of the first dispute board, a review board in Colorado in the USA. Now, we know a little bit about this board from notes drafted by two of the members, Al Matthews, an engineer, and Palmer King, a lawyer. And there's a couple of their notes up on the screen for you there. And you can see the basic problem they had. The tunnel came in 2 digs, in 2 bores, and the first bore was a complete and utter financial disaster. They made losses of some, or claims were paid out of some $50 million. And the parties obviously wanted to do things a lot better in the second half of the project. And the way they decided to address the challenges they'd faced in the first part was to set up a review board. And you can see that I think it's Palmer King who mentioned that with the second board, the biggest problem the board has was that they went along for 2 years with no problems. Now, that will have been for a number of reasons. In part, the attitude of the parties themselves. They didn't want to make history repeat itself, and so their attitudes may have changed. But in part too, it's the fact just the mere presence of a panel of neutrals, and that was able to provide a sound base for cooperation and collaboration to enable the parties to work together and avoid disputes. In the end, there were 2 or 3 claims, but I think the value of those claims was just a few $100,000, a significant sum, but nothing compared to the $50 million when there wasn't a review board in place. To take a slightly more recent example, in Peru, in Lima in 2019, they were building 5 stadia for the games, athletic stadia and football stadia and the like, and they were using NEC3 contracts, which at the time didn't actually make provision for dispute boards. But what the parties wanted to do was to work together and take advantage of the dispute avoidance elements that boards provided for. And the use of the boards was so successful, there were no disputes, that the Peruvian government actually changed their legislation and they modified the state procurement law, and they make dispute boards mandatory for resolving disputes in all public construction projects costing over $5 million US. And you'll see that other governments which have also mandated the use of dispute boards on government projects, for example, Indonesia, Honduras, and Brazil. And even the NEC have changed their contracts, and NEC4 now makes provision for dispute boards. So there's a couple of practical examples of the value of dispute boards, but there's also been some research about whether or not, or the extent to which, dispute boards add value. To look first at the Florida Department of Transportation. Cost, always an issue, always a concern. In 2013, the Florida Department reckoned they had about 750 projects with a dispute board. The average cost was 0.1% of the total construction cost. They also performed an analysis comparing the performance of projects where there was a dispute board against projects where there was not a dispute board. Now you can see from this slide that where there was a dispute board, the time overrun was 1.8%. Where there wasn't a dispute board, it was almost 20%. That's a huge, significant difference. And there was a difference too in costs. The cost overrun was 12% with a dispute board against 18% where there was not a dispute board. The result of that, perhaps unsurprisingly, is that Florida now used the dispute board process for almost all their contracts. And they've seen in the past 25 years that litigation has plummeted. There's more recent research. At the end of last year, King's College London released the results of their survey, which had been running for a year. Now, they looked at 6 years of dispute board practice. They asked 307 questions. They found details about over 5,000 dispute boards, and there were over 200 respondents, including, thank you very much, a number of development banks and funding agencies. I think your contribution to the survey definitely served to add value to the results. And one of the reasons why the survey was so important was explained by Sir Vivian Ramsey when the report was launched in London at the end of last year. He said the report allowed reliable data to be collected on all the topics about DBs, where there was until now, with a few exceptions, for example, Florida, and also some DRBF research, there was only anecdotal evidence. There isn't time today to go through all the report, but I just wanted to take a couple of examples to demonstrate the effectiveness of dispute boards. Now, one of the issues is, what's the point having a dispute board make a recommendation or a dispute if the parties are simply going to make a referral to litigation or arbitration? Well, King's found that in almost 70% of the time, decisions and recommendations weren't referred to arbitration or litigation. And they also looked at what happened to those that were actually referred to arbitration. Were they reversed, or did the tribunal agree with the original dispute board decision? And you'll see that 79, almost 80% of the time, the decisions were not reversed. They were either never reversed or rarely reversed. And this, in fact, mirrors some research that was carried out by the DRBF in the period up to 2018. And they looked at about 2,800 projects, and they identified some 512 decisions. Only 6%, or 32, were referred to arbitration. And of those, only 7 were overturned. So that's 1.37 of all the formal decisions were actually overturned. Now, that suggests that dispute boards tend to get things right at the outset, at the beginning. And I think that's quite useful. So one of the criticisms is, well, we're just going to go and we're going to get that decision overturned. I've mentioned briefly cost, and another of the criticisms of dispute boards is the cost. And I've got there referenced again to the Florida figures of 0.1%. Well, it's very similar to the figures that King's College London and the DRBF were able to find out about. For the DRBF, it was between 0.2 and 0.6%. For King's, most projects, the cost was under 1%. Now, I appreciate that that still can be quite a lot of money, but it pales into significance. It's considerably lower than the time and costs involved if you end up in a contested arbitration after the project. Sometimes these arbitrations last longer than the projects themselves. And I just wanted to finish with a word about dispute avoidance. So something I sort of began my words with earlier. And King's looked at how often were dispute avoidance measures adopted. And it was about 50% of the time. So as I said, it's a trend that dispute avoidance is being used more, but it doesn't mean it's being used all the time as yet. So I think more importantly was, what was the result of the adoption of those dispute avoidance measures? Well, in almost half the time that it was used, the dispute was completely avoided. And as importantly, in 40% of the time, the scope of the dispute was significantly reduced. And that would enable the parties to reach a decision in longer term. You might not be able to resolve everything straight away, but you've narrowed the dispute. There's less to argue about. There's more chances of being able to move the project forward. And that's 86%, almost 90%. The adoption of dispute avoidance measures significantly, if not entirely, reduced the conflict that was brewing. And again, interestingly, that's quite similar to the research that the results of the research from the DRBF's figures. Again, they had a look to see whether parties were using dispute avoidance, and they were about 55–60% of the time. Were they satisfied with the dispute avoidance? Yes, they were. Very high figures in most areas to say they were satisfied with the dispute avoidance, almost 90% or 90% plus when you actually look at the figures. So you might be wondering why, if all the research is demonstrating that dispute boards can be very effective in helping parties progress to time and to money, and helping parties avoid finding themselves in arbitration or litigation once the project ended. One of the interesting questions that was found in the survey, we asked appointing entities, we asked some of the funders whether they had a rule or policy for including a dispute board in all or certain of the projects in which they were involved. So they have this rule, but many people actually reported that, having discussed the inclusion of a dispute board at the procurement stage, the parties, not necessarily the funders, then decided not to include the dispute board. And if you remember right at the outset when I talked about the purpose of the paper that we're going to sort of discuss, we're discussing today, it was really to see why, what can be done to increase the number of dispute boards that are actually adopted on projects. Why is this happening, and what can be done? And so, having introduced dispute boards and talked about the recent research, I was going to leave it to my colleagues, Nabil and Richard, to explain further some of the findings of the report and some of the outcomes that the report had introduced. So, Nabil, I'll leave things to you. Thank you very much.
Jeremy, thank you very much for summarizing the first part of the paper. And as you highlighted, the track record for the use of dispute boards is solid. However, the implementation is where the challenge arises. And our paper has addressed some of these practical challenges faced by the implementation. And we've also humbly suggested possible solutions that could be taken to overcome some of these issues. So during this part of the webinar, myself and my colleague Richard will take a closer look at some of these challenges and the proposed proposed solutions that we have suggested. I'm going to take 4 topics, and if you are looking at the paper, then those topics are going to be the party sabotage, the cultural biases, the lack of the geographical diversity of dispute board members, and the lack of borrower compliance. And you may well see that there are some links between some of these challenges. So if I can start with the party sabotage challenge, in our paper, we say that parties are not convinced by the value add of dispute boards, or that they even work. And they'll often sabotage the process by failing to constitute a board, either at the very onset of the project that is the most beneficial, or even not at all, or ever. And this is done in various ways, some quite creative and some quite obvious. It's either by indefinitely delaying the nomination of a dispute board member, or by simply deferring the membership at all. I recall I was on a project in the Middle East, and as the contractor, we nominated our dispute board member quite early, and we then tried to push to try to get the employer to nominate their dispute board member, but it just never ever materialized, and we ended up going through the whole project with no dispute board member at all, which was sad because would have been quite beneficial. So the parties are hoping to rely on dispute boards. But why is it that this doesn't work? And what are the possible solutions to the party sabotage? Funders can insist on formations of dispute boards or standing dispute boards to encourage them to comply with their contractual obligations. And we must also remember that the appointment of a dispute board is a contractual obligation upon both parties. You could even go into a situation where at the tender stage there is a pre-agreed list of DB members that are available to both parties to pick between. So some of the problems of the sabotage is that there are so many names out there that that possibly one gets lost. But if you are to agree a pre-agreed list, then that would probably reduce that problem. We tried as one party to push the other party to try to appoint their member, and used the issue of possible contractual non-obligation, and that was one possible way. I mean, the last resort is to approach the nominating body that's normally in the contract, but that really should be a last resort. It's never wise, because parties then don't really get a choice, and it is much better to nominate a disputable member who you would like to have there. The best solution, I suppose, is to target education to both parties, that to actually have a dispute board on their project is much more beneficial. And some of the statistics that Jeremy mentioned at the very beginning are extremely useful. And I think if they are much more widely distributed, then there is that obvious benefit. It's always a lack of knowledge that's always the highest hurdle. So if that lack of knowledge can be taken away by training or by education, then there's a possible situation that party sabotage could well be a thing of the past. I'd like to move on to cultural biases, and I don't want to underestimate this challenge. It may well be simply that some jurisdictions just don't want to have a dispute board as part of their sort of contractual way of solving disputes. They historically possibly have their own way of dealing with things. They don't want other people or outside people coming in and telling them how to do things, or this is the better way. There's also a view that possibly dispute boards can be condescending, not understanding maybe cultural nuances. I mean, I've been involved in projects in the Middle East, and these and Africa and the Far East particularly, and these regions have very proud history and heritage and their culture, and instruction from the outside isn't always welcome. Indeed, there may well be a situation where in some jurisdictions that an award from a dispute board isn't enough. They would rather have a legal award or a legal decision, because that is seen to be much more powerful. And as Jeremy said, that if that is done, then normally speaking, the answer that you're going to get is very similar to what the dispute board has told you anyway. So that's also something that is there, but maybe can be challenged. Again, knowledge is a key one. Difficult, but it is vital that dispute boards and parties are aware of cultural nuances before they go into contracts. Consideration's got to be given to dispute resolution methods that have been used elsewhere, within that region, possibly, for example, in some Far Eastern countries, jurisdictions, confrontation is just not welcome at all, and any form of confrontation is seen as something that is not part of their way of dealing with things. But as Jeremy also mentioned, just the dispute avoidance element of dispute boards could be a possible solution to that issue. Again, education and training is again a big part of that. but possibly that training that we're talking about here needs to be culturally sensitive in order that it's accepted in the way it's supposed to be, rather than seen as something that is, again, telling people how to do things. Another interesting issue with regards to the cultural bias is that quite possibly maybe recommendations of dispute boards rather than awards could be a way of going in these areas, because then you're only recommending a course of action rather than stipulating that it is an award, and possibly that might go a little bit or a long way into solving the issue of the cultural biases. Connected to that is a challenge of the lack of geographical diversity of dispute board members. The question is, can international dispute board members, they are fantastic in their approach, but can they properly understand local culture and take consideration of the way in which things are done? It may well be that there are nuances in certain regions that possibly only people from that region might be familiar with. Right at this present moment now, a lot of the Islamic world is going through Ramadan, and that has an enormous impact upon progress and operations on site. And just having a knowledge of how that affects people themselves in that time is important, and maybe, as fantastic as the international DB members are, it might well be that there are small nuances that they're not really aware of unless you are from that region or have extensive experience in that region. How can we get over some of these issues? Possibly appointing at least one member of the board who is from the regions we're talking about, or has a knowledge of certain issues. For example, the Islamic issues. It might be an idea to have someone who would be aware of what those nuances might be. Parties should ask DB members to give their experience of these regions, and to honestly give out their work that they've done in that time. And district boards should, if they're standing, have that learning function where, as the project evolves, then they do get to know a little bit more about the local customs, and possibly the site visits are a fantastic opportunity to really get to know how the operations of that region. Once again, I'm going to mention training and education, but possibly angled more towards localized training, possibly empowering local professionals or regional professionals to have the same level of expertise as international colleagues, and being able to provide the high level and high quality of dispute board members' services that are required to really see the benefits. So again, education and training is probably high on those list of possible solutions. I'm going to end with the challenge of a lack of borrower compliance. MDBs and IFIs generally require the use of the 2017 FIDIC conditions, and they have a particular wording in their clause 8.1 that states that the notice to commence can't be issued until there is a DAB constituted in accordance with 21.1 and 21.2. All sounds really good, but where's the challenge, you might ask? Well, it might well be that MDBs and IFIs are rather reluctant to mandate this compliance, and hence there are no DABs in place at the onset of the project, or not even at all as the project commences. Possible solutions to that: should MDBs, IFIs consider implementing the practice of refusing to disperse funds to borrowers unless and until a dispute board has been put in place. Possibly lenders should enforce the mandatory nature of the use of DBs to their borrowers under their loan agreements. And maybe later on, if there is a DB in place, then they should prevent borrowers from avoiding payments and obligations that are placed upon parties for payments that need to be honored. So I'm going to close there and hand over to Richard. But just to say that the challenges that I've tried to highlight here, more often than not, the proposed solutions do evolve or involve training of some sort. It's always to try to increase the knowledge of DRB members and of parties, and education is always probably the best way to go. Thank you very much, Richard. I will hand over to you.
Thank you, Nabil. Thank you very much. Dispute boards, right. What do contractors think of dispute boards? As far as I can see, the contractors' view on dispute boards are pragmatic. They definitely recognize the value of the system for the simple reason that it's quicker and supposedly and generally cheaper than arbitration, especially when it can avoid arbitration, and also less uncertain than litigation in court. But contractors are not entirely happy with the present situation for at least two reasons. First, statistically, the cost of DBs may look more than reasonable. And this was, I think, demonstrated in a way by Jeremy a moment ago. There may be some truth in that. But for most contractors and for many employers as well, the cost seems expensive, especially when they compare their daily income with the daily fees that are charged by the DB members. But there is an indisputable legitimacy in the higher remuneration of DB members, I should say, considering the expertise and the experience required to perform their duties. But it's also a market, and the scarcity of persons qualifying for DB members plays a role in the level of their fees. There are about 120 persons on the FIDIC list, and most of them are busy working on several DBs at the same time. Their availability is limited. This situation is an incentive on the parties either to refrain from setting up the DB, and Nabil has spoken about sabotage, or to sabotage the system, definitely, or to prefer an ad hoc DB instead of a standing one, which would be a pity, or to appoint local DB members, supposedly cheaper, and whose travel costs may be lower. I have experienced a DAB in Hungary where the contract imposed a Hungarian citizen as president, and where the employer appointed someone from its own staff as DB member, a civil servant who appeared, by the way, to be the president's best friend. It was not my easiest experience in DBs. But eventually, frankly enough, it turned out to be positive, favorable. So there are solutions to this problem of cost. First, DB members should remain reasonable as far as fees are concerned. I know some of them who would shout at me if they heard that, but it remains my position. Second solution, potential solution, more potential DB members should be identified and trained, especially in the low and middle income countries, to increase the number of persons qualified to become part of standing DBs. Nabil has expressed his views about that as well. But there remains a difficulty when the fees of the members in the DB are too different from one another, and the members happen to know about it. This may cause some trouble. because everyone wants to be on an equal position, and it may be a real problem. The second reason for the contractor's discomfort with the DBs is that in many instances, the DBs are not adequately fulfilling their needs. First of all, when the DB exercises its dispute avoidance task, quite often it tends to behave like a mediator, trying to obtain efforts from both parties to the contract. For the contractor, this means that it has to give up on some part of its claim, and this effort may not be justified, or at least may not be felt as justified. And second, when the DB is designed to issue recommendations instead of decisions, this is even worse, because either the parties have to enter into negotiations where the contractor will eventually end up losing something, or because the employer will just refrain from applying the recommendation and do nothing in order to avoid the suspicion of corruption, a matter which is of utmost importance in many jurisdictions. Arbitration then becomes unavoidable, and the whole DB process has just been a waste of time and money. I know Jeremy may not be as radical as I am on this topic, but hopefully you will have opportunity to reply on that. The solution to these problems is to give preference, in my opinion again, to decision-making DBs, and to insist on the idea that dispute avoidance must remain distinct from mediation. There are a couple of other issues that contractors have with DBs. One of them is time. Many DB members are practicing lawyers, and quite often they are also arbitrators. They tend to handle DB proceedings in such a manner that there is little difference between them and arbitration proceedings. The result is that the 84 days stipulated by FIDIC, to take that example, are not often respected. Another issue relates to the distribution of costs. The contractors consider that the losing party should bear the costs of the proceedings, and that the DB should be empowered to make that determination. This is presently not the case, at least in the FIDIC conditions. In conclusion, contractors love dispute boards and dispute board members as well, and love them so much that they would like more of them and give them more power. We are confident that the multilateral development banks can be sensitive and helpful on those matters. Thank you for your attention.
Thank you so much, Richard. That was great. We don't have any questions right now in the Q&A, but if anyone who is signed on would like to drop one in, we'll certainly stay on and answer those. One thing that I'd like to react to is several of you talked about the importance of education and training, particularly Nabil. And I know that that is something that is near and dear to the DRBF's priorities as an institution. So one of the things that we're working on is a great enhancement and expansion of our education and training program, both for users and for the dispute board members. So we do offer training for the MDB procurement teams. That's something that we've done in the past and will continue to do and expand. We're also developing programs for practitioners to get into some of those techniques that you were talking about, Richard, understanding the difference between mediation and dispute boards, the difference between dispute boards and arbitration techniques. So that is something that we are hoping to really expand and amplify in that development of new candidates fulfilling that need to serve in various locations around the world. understanding those cultural nuances that Nabil was talking about. And then lastly, also to educate and train the users themselves, the project owners, employers, and contractors on those essential elements around board member selection, the importance of instituting the board at the start, that standing board gold standard that you talked about, and also how to interact with the board throughout the project so that they're really getting that efficiency and that maximum value that they're looking for this process. So I appreciate you all raising those important topics, and it's something that we hope we can rise to help meet. I don't know if Jeremy wants to comment on that.
No. I mean, I think that it was obvious from the comments made by Nabil, the value of education and training. And I think it's important to stress, as you have done, when we say that, it's across the board. It's dispute board members, even the dispute board members who've been around a long time and are considered to be very experienced and are very good, and they're very good for a reason. They need training from time to time as contracts evolve, contracts adapt. And also when we talk about dispute avoidance, which is a reasonably new concept, but equally for users of dispute boards, I think some training in how they actually work can be quite valuable. But obviously, I was invited to respond to one of the comments made by Richard, and to some extent, I agree with your comment that sometimes there can be little point in there being a dispute board, and that is when there's right towards the end of the project, and if there is a whole series of disputes, in the UK we would say it'd be a traditional final account dispute, then I can see little value in running the same dispute twice. There may be a value in running it with a dispute board who is familiar with the project, and they're pretty likely to get a good answer, than waiting, and then as opposed to waiting 2.5, 3 years to have everything looked at again in arbitration. I mean, that I can see that it's still going to be more costly than a dispute board. But I think really what a good dispute board should be looking to do is avoid that situation occurring in the first place. And that's why we place such value in setting up a dispute board at the outset of the project. It's really important, maybe as part of the procurement process, that steps are taken to ensure that a dispute board is there in place right at the beginning, because then they learn with the project and they get to meet the people who run the project. They start communicating with those people. And that's one of the biggest ways, communication and collaboration, that a dispute board can actually add value to the project. They get to know who the people are, and that's how they can use their experience to help avoid disputes. They can see when things are getting difficult, and they'll be bold enough and experienced enough to raise the issues in such a way that they can be discussed. I mean, sometimes it happens that people know that a dispute board's coming for a site visit, and they think about what are the issues that are actually going, potential issues, a disagreement, and they want to try and resolve them. There are many different ways that a dispute board can influence things, but I think, and I think that's the key element, is trying to get a dispute board involved in the project at an early stage, so you don't lump all the disputes up at the end.
Yes. Jeremy, if I may, the issue of education and training is something that is a hot topic, and I think you very rightfully mentioned that the training is across the board, even down to maybe more down to employers and clients, because I think as contractors, we at EIC we're pretty familiar with dispute boards, and as Richard mentioned, dispute boards are perceived to be our best friends. Unfortunately, that's not the case when it comes to employers and clients. When in fact the dispute board is there for the best for both parties, and the project itself, it's not there for any one particular party, and that perception is probably a challenge that needs to be resolved, in the fact that dispute boards are there for the best for project rather than best for any individual party involved in those projects. And I think that's education and training along those lines may well go very far in further implementation of the boards themselves.
No, I mean, I think that's very interesting. At the DRBF last week, we held a conference in Skopje in North Macedonia, and we began the conference with a workshop. The workshop was attended by a large number of people from government ministries, from procurement agencies, not just from North Macedonia, but across the region. And some of them were familiar with dispute boards, some of them were entirely new to dispute boards. And I think one of the topics there that was being addressed was the one you said there, you know, a dispute board is a contractor's friend. And there was a very lengthy discussion about the ways in which you appoint a dispute board members and who the right people should be to be on that dispute board. There was recognition that, as you think the example you gave, you couldn't put on a dispute board someone from your own company or someone from your own ministry. And everyone was stressing the importance of independence and impartiality. And also one of the points you made, Nabil, about local understanding, understanding the local cultural issues. And that could be because it's someone who resides in the area, perhaps not the country where the work is being carried out, because independence, but it can also be dispute board people who have got experience working in the area. But there's also quite a lot of enthusiasm for the idea you suggested about the makeup of the dispute board, perhaps looking to include one local member and two traditional international members, partly to deal with the cultural issue, and also partly to, I mean, capacity building isn't quite the right word, but to help increase the pool of diversity of potential dispute board members. So we want people from all experiences and backgrounds. Yes, I'm a lawyer and I am a dispute board practitioner, but I tend to sit on dispute boards with engineers and other people. I think the key is you want someone who understands the construction and engineering process, a construction professional. I can see we'd had one or two comments in the chat. If anyone wants
We sure have, Jeremy. So there's a comment from Roberto Laguado, who is the regional procurement coordinator for the Inter-American Development Bank. And I'll just summarize his comments for everyone here. He notes the importance of working on the interrelation between loan agreements from financiers and borrowers, and above all, to carefully review the dynamics of disbursement rules and the nomination of members for dispute boards, something you've just been talking about. He notes there are certain technicalities that may not necessarily allow for the implementation of these ideas, and he's keen to continue exploring these topics in other forums. He goes on to say that on one hand, they're working very closely in countries such as Bolivia and Ecuador, which have recently established regulations on dispute boards. They're leveraging their synergies on the ground there so that both the IADB finance projects and the local practices, which are still in the early days, can better align and develop projects that integrate the rules of the MDBs with local regulations. And he sort of reinforces this idea that the DRBF and other experts should be engaging with both the governments to collaborate on developing the market, the practices, understanding of culture, etc. So, any response and reaction to his remarks?
Maybe, Anne, just to complement your answer to Roberto, I would like to add that we will be in Washington at the end of May, and we have already arranged a meeting with your colleagues at the Inter-American Development Bank. So we would be very pleased to discuss the technicalities and in general the dispute boards in Latin America, with also our colleagues from the construction chambers in Latin America. Thank you.
It's interesting, the comment in relation to the dynamics of disbursement rules. I think there's one or two funding agencies who actually include the costs of the dispute board within the loan agreement, or will provision be made for the dispute board cost perhaps to be a provisional sum, and that helps to encourage the adoption of the dispute board, because the parties, and perhaps here in particular the owner, potential employers, can see that the potential costs have actually been covered and thought about up front as part of the overall loan agreement. But of course, as Roberto says, there are technicalities and challenges, and that's not always an option, but I have seen it work quite successfully.
We have another comment from Doug Frazier, who's with the Caribbean Development Bank. So he's grateful for the paper and this discussion. Thank you so much for that, Doug. He's glad to see our organizations collaborating on this issue. He does have some comments about the sabotage that was discussed in a number of forums, including budget not being allocated to the DAB by employers, despite the fact that they can finance the employer's costs. And he says he would agree with the need for sensitization and training at the regional level with procuring entities, contractors, and engineering consultants. He notes there's a real need to develop regional adjudicators to blend with international experts. And there are some regional centers that could work with our groups, with our interested parties. Any comments on Doug's remarks?
Yeah, and if I may, I think the issue of sabotage is rooted in many different sort of fields. Cost, I guess, is one of them, and if there are budgets allocated for dispute boards within the project funding, then that goes a long way. But I think that the issue of training, as you mentioned, or as was mentioned, at a local level, I think that's a really key one. I think that the overall workings of dispute boards and what makes a good dispute board, and as you mentioned, Jeremy, the nuances of dispute avoidance, which is a relatively new sort of concept. That not only has sort of global issues, but maybe regional and issues of how dispute avoidance can be practiced at a regional level. It may well be that certain techniques and what have you at a more general level may not be applicable to certain regions and certain jurisdictions and areas. So possibly regional training on topics is probably something that would go a tremendous distance in getting dispute boards accepted as the norm on projects.
I would just simply agree with Nabil. The idea of the regional centres is, I think, a good one. There's opportunity to provide training, as Anna said, for procurement teams within banks and agencies, training for those who will act as owners, employers within government agencies, procurement bodies, and potentially potential dispute board members as well. And I think this idea of a sort of 2-1 spread is a good one for the time being, and in time we will have increased the pool of potential dispute board members, so we don't need to talk about that type of thing in those terms anymore, which must be the ultimate goal, to have a strong pool, a global strong pool of potential dispute board members.
Very good. Well, I think we're coming to the end of our session. I'd like to thank all of our speakers for participating today and bringing forward these important topics, but also their personal experiences, sharing some of those examples from projects that really bring these issues to life for everyone. Thank you to our attendees. We appreciate your contributions and input, and we will certainly keep the conversation going in our future meetings. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.